All right, welcome everyone. My name is Amy Herstuck and I am the Education Chair for the UB Law Alumni Association and immediate past president and current director for the NFCCA. Thank you all for attending today's presentation. Today's CLE is a free benefit for both organizations, and we thank you very much for your support, which helps to underwrite our annual programs and events. For those of you who are not members of the UBLAA, please join online today. So this is one in a series of many virtual programs that we're putting on and hosting for our alumni and students during the COVID-19 pandemic. Our next session, CLE session, will be June 12th, and it will be on employment-based immigration and the impact of COVID-19 on that. Following that, we will have a CLE and ethics CLE on June 23rd, entitled Walking an Ethical Tightrope, How to Protect Yourself in Court When You Disagree with Your Client. And we'll have a judges panel for that one, so please join us. If you're interested, you can register on the UB Law website at law.buffalo.edu/alumni events. It is now my great pleasure to thank Bond Schoeneck & King for sponsoring and presenting today's program on addressing COVID-19 employee concerns as we all return to work. I would especially like to thank Jessica Copeland for managing all of the logistics and Dennis Schaefer, also a UB Law Alumni Association board member, for his support in that effort. In addition, I would like to thank our speakers, both UB Law alumni, Mike Hickey, 09, and Mary Aldridge, 18, and also Kimberly Wolf Price, who is a Syracuse law grad, but we welcome her with open arms today. So thank you all.
Thank you, Amy. Thanks very much. And thank you all for joining us today. My name is Kim Wolf Price. I'm the Attorney Professional Development and Diversity Officer at Bond Schoeneck & King. I'm also a member of the Buffalo Niagara Partnerships Diversity Executive Council, so I'm active in Buffalo Niagara area activities as well. Mike Hickey is a member in our Buffalo office, and Mary Aldridge is an associate. Did I say Albany? My gosh, Buffalo office. Sorry, guys. I was like, did I say the right office? Sorry, it's one of those days. In our Buffalo office as well. Both are in our labor department at the law firm. And they are, as Amy said, they are UB alum. So I'm just UB alum by association, not actually UB alum. I do also want to thank Jessica, who's co-chair of our cybersecurity and data privacy practice group, Jessica Copeland, for putting this together today. And thank you to the UB Law Alumni Association for giving this opportunity to connect with you all and to present for you today. As the diversity officer for Bond, I was very happy to be part of this presentation. So before we get started, as with all CLEs, we have to do some housekeeping to make sure that we all get our credits. First, you should know that this program is being recorded. That includes the question and answer and chat features as well. Later in the webinar, you will be given a code by one of your speakers. That code is required for credit. It is to be added to the affirmation you received in an email today. The email has all the other information you need except the code. You have to look for it. If I remember, I will also type it into the chat so you have it. Our program runs just over 50 minutes, which is 1 hour in CLE speak. The program has been approved for 1 credit of diversity, inclusion, and elimination of bias under New York State CLE rules. The panel will try to leave a few minutes for Q&A at the end of the presentation today. Please use the Q&A feature on Zoom to enter any questions. You can enter them at any time. And sorry, someone is saying they can't hear us in the chat. I think everyone else, other folks put in that you can hear us. Okay. All right, so great, thank you, Emma. Thanks for letting us know. I will, if questions are more immediate, I will let Mike and Mary know that they're coming, but otherwise we'll address those at the end of the conversation. PowerPoints will be used in today's presentation, so our suggestion for the best experience is to use Speaker View on Zoom, so you see that speaker and the PowerPoint as they're coming up. All right, so as Amy said, our program today is avoiding bias and managing high-risk employees in the workplace upon reopening. When I pass this off to Mary, she will begin by providing some general definitions of bias to give us a bit of a foundation, because you know we lawyers love setting the stage and giving a foundation for our conversations. I ask you to remember that identifying bias or potential bias-related thoughts or activities is not always about placing blame or feeling blame. I know that we as lawyers like to think of things in that adversarial mindset that our profession teaches us, but when we're talking about bias in this context, it's client counseling, management decisions. So try to think of it more in these terms: education, considering other perspectives, workplace culture, best business practices, prevention of bias, or risk management. Also, I think it's important that we say today, while racial justice issues are of critical importance at all times, and certainly are very present for all of us at this moment in history, today's presentation is not meant to and will not cover those topics. This program was in the works for several weeks and will focus on being attentive to potential issues of bias in reopening our law firms and other businesses after the COVID quarantine. We could not cover racial justice, racism, and bias topics in 50 minutes, let alone add it to the 50 minutes we have here today. With that said, any discussion or addressing or examining bias helps us all to be more open and attentive to these situations we are in. It reminds us to take that moment to pause, to pull back from our personal perspective, and to see situations more fully and hopefully from the other person's perspective. When the New York State Bar Association's Diversity and Inclusion Committee first proposed the D&I elimination of bias credit, we did so with the understanding that the best way to combat bias is continuous education and discussion. And the purpose was to help us all work together, be better advisors to our clients, and strengthen our profession. Because while unfortunately bias may remain, the world changes. 6 months ago, who would have thought we would have an audience of well over 100 people to discuss how a virus may have a bias impact on age and reasonable accommodations for health conditions? I don't think any of us would have signed up. We wouldn't think that would be necessary, but here we are. So I'm going to turn this over to Mary now, and she and Mike will take the presentation from here. Mary?
Mike, you can advance it a couple slides. There you go. Perfect. Thanks for joining us today. Thanks, Kim, for that introduction. Thanks everyone for joining us for this program today. I hope everyone's doing okay during the shutdown so far. Settled into a new lifestyle, maybe. Maybe you have a new hobby or two over the last few months. I actually took up golf, and it's been a humbling experience. It's a lot harder than it looks, but trying really hard. Anyway, so we have two parts to our presentation today. The first is, so this is a diversity and inclusion CLE, so we're gonna present on the topic of implicit bias, which I think is a really fascinating concept, and pardon the sirens outside, bad timing. But secondly, after that, we're gonna dive into the world of labor and employment law a little more specifically. So Mike and I are going to talk about employees who are considered high risk with respect to COVID-19 and some of the legal issues that come up when businesses reopen and these employees start returning to work. All right, let's jump right into it. So let's just start with the basics. So implicit bias refers to subconscious attitudes or stereotypes that people have. So an attitude is an association between a concept and an evaluation, or an evaluative balance, which just means either positive or negative. So an example of an attitude is a child could have a negative attitude towards math class, for example. So the concept is math class and the evaluation in this case is negative. So implicit bias exists when the child does not necessarily come right out and say, I hate math class, but rather gets into a bad mood every time they walk into the class, or the experience in the class otherwise invokes negative feelings somehow. That child is me, by the way. So a stereotype is an association between a concept and a trait. So an example of a stereotype could be that pit bulls, the type of dog, are dangerous. So the concept there would be pit bulls and the trait would be dangerousness. So implicit bias exists when a person subconsciously associates this concept of pit bulls with this trait of dangerousness. And the implicit bias could be manifested if a person, for example, without even realizing it, goes to the dog park and won't pet a pit bull, but then has no problem petting a lab or a golden retriever or whatever. And it's all subconscious without any knowledge at the forefront. So to summarize these concepts, implicit bias exists when we subconsciously have an attitude, which is a concept plus an evaluation, or a stereotype, which is a concept plus a trait. Right, next slide, please. Okay, so we all have biases. So now the question is, where do they come from? So we as humans are constantly inundated with information or stimuli all day, every day. So our brains need to process this information efficiently for us to be able to function in every facet of our lives. So in order to do that, we naturally seek out patterns in this information that we receive, and this can inevitably lead to the formation of biases. So I like to think of our biases as like mental shortcuts that allow us to react to certain information quickly and efficiently, and it's based on experience. So that experience that forms our biases can be shaped by direct personal experience or perhaps media portrayal of the concept, or through cultural conditioning, which is the process by which authority figures such as our parents, peers, religious leaders, teachers, etc., define our values and shape the way that we perceive the world. So in my example with pit bulls in the prior slide, perhaps that person at the dog park has had personal experience with an aggressive pit bull in the past, or maybe read news articles about it, or someone they know told them a story, or the parents warned them about it, anything like that. So all of these inputs can cause a person's brain to make subconscious associations that affect their behavior without the person even realizing it. Thanks, Mike. So now that we've discussed what implicit bias is, I want to talk a little bit about why we should care. The problem with implicit bias is that it can be destructive for both the subject of the bias and also the person that's applying the bias. So the obvious downside here, I think, is the unfairness to the subject of the bias, who may have a trait ascribed to them or an attitude projected towards them that doesn't really have any basis in reality for that person. On the other side of things, these biases can be destructive to the person holding the bias, and this is perhaps less obvious because it really presents a lost opportunity. So in this instance, that person is closing themselves off to what somebody else has to offer because they've already reached a conclusion that's not based on anything specific to that actual person. So for example, there's been a lot of studies on this, and one study found that college faculty in certain circumstances are less likely to respond to an email from a student inquiring about research opportunities if the email appears to come from a woman rather than a man. So I think the potential lost opportunity is pretty apparent there. Next slide. Okay, so I don't know if any of you have read any of Gladwell's books. I admittedly have not recently. I've had a lot of employment laws to brush up on lately, so that's my excuse. But Gladwell had a really nice passage in his book, Blink. It's up there on the slide. He says, all of us have implicit biases to some degree. This does not necessarily mean that we will act in an inappropriate or discriminatory manner, only that our first blink sends us certain information. Acknowledging and understanding this implicit response and its value and its role is critical to informed decision-making and is particularly critical to those whose decisions must embody fairness and justice. So I really like this passage because I think it shows the value in recognizing our biases, and that's something that I was hoping that everyone would be able to take away from this talk today. All right, next slide. Okay, so unconscious biases are a fact of life, as we've discussed so far. Everybody has them, and they permeate every part of our lives. So the workplace, of course, is no exception. We spend a lot of time at work, and our biases are inevitably going to creep in there. So there have been various subjects on this topic, some even finding that something as simple as a person's name can actually affect the opportunities that they're afforded. An interesting and unfortunate phenomenon that I wanted to bring up is that our natural biases can be exacerbated in times of crisis. when people are anxious and uncertain, they might act in ways that they might not ordinarily act. So if you take a look at the picture that's on the screen, that is, I believe, a Snapchat. There was a time in my life where I thought that Snapchatting was a good use of my time, and I've come a long way since then. But I think that this picture here is actually a really artful display of social criticism. And this is, of course, a man wearing a head covering at the airport, and there's TSA agents in the background, and it's of course calling into question whether random searches by the TSA agents at the airport are actually random, or if they're driven by the biases that are held by the people that are making this so-called random selection. So I guess it's easy for me, looking the way that I look, to never think twice about random selections at the airport, but perhaps if I looked like the man in this picture, I would have a different experience. And so this is an example of how certain biases could be exacerbated following the 9/11 crisis. Of course, we're all dealing with a crisis, or at least one crisis right now. I was referring to the pandemic specifically, so it's extra important to understand how our biases might be affecting our actions right now, even more than they ordinarily would. So another angle to the bias problem that's particularly prevalent in crisis times is what's called a hostile attribution bias. So the essence of a hostile attribution bias is that when others do something that we don't agree with in times of high stress, we tend to attribute a hostile intent to them. So I have a personal story about this one that I experienced recently, just in the last couple of weeks. So I don't get out much lately, but I do go to the grocery store. And when I go to the grocery store, I always have my face mask in my purse that I bring with me. And typically what I'll do is before I walk into the store, I'll just take it out of my purse and put it on my face. And on this one particular day, I, had my face mask in my purse like I always do, but I walked in, and for some reason, I just completely forgot to put my face mask on. I don't know, was maybe a little excited about like the avocados on sale or something, but for whatever reason, I just didn't put it on. And I was the only person in the whole store without it on, didn't even notice. As you can probably imagine, I was confronted rather quickly for not wearing a face mask. A person came up to me and said something along the lines of, it might not be comfortable for you, or you might not like it, but it's really, you have to do this, like to stop the spread or whatnot. And I was like, oh, like I didn't even realize I wasn't wearing it. And I'm like, this person was assuming that I was pushing some sort of anti-mask agenda when I literally just forgot. And I didn't have that hostile intent that was being assumed. It was just something completely benign in a sense. So it's kind of an interesting experience that happened just recently. Next slide. Okay, so as I touched on in the prior slide, the pandemic has created the potential for increased bias because it's a crisis situation right now. And this could be particularly problematic as businesses begin to reopen. So I'm sure, as most of you know, the state of New York has taken a phased approach to reopening businesses. There are 4 phases, and Western New York is currently in phase 2. Phase 2 includes office-based jobs, real estate services, among other industries. So if you want more info on the phased reopening, I'd recommend going to forward.ny.gov. Save it to your bookmarks. It's one of my most frequently visited websites these days. The issue with this gradual phase-in is that many employers probably will not be bringing back employees all at the same time, which necessarily involves some sort of selection about which employees are coming back and when. So bias could potentially influence the selection process. So for example, an employer could be inclined to exclude certain groups from reopening initiatives, such as older workers, parents with children, or people with disabilities. And these are all protected statuses under federal and or state law. So when an employer starts to make decisions based on an employee's protected status, there could potentially be discrimination issues under statutes such as Title VII, the Human Rights Act, or the New York Human Rights Law, which I'll discuss more in a couple minutes. As a side note, it may be permissible to bar certain employees from the workplace if they pose a direct threat to workplace health and safety. That's okay, and Mike is going to talk about that more later on. So our takeaway here is that employees should not be excluded from reopening based on our biases that are applied to them. Quick note on Matilda's Law. There's been a lot of confusion on this. Matilda's Law is named after the governor's mother, and it mandates that individuals over 70, as well as those with underlying illnesses, stay home and limit their visitation. So the thing about Matilda's Law is it's not a law. That's why I put law in quotation marks. So Cuomo mentioned Matilda's Law in a press conference, kind of off the cuff back in March, but it never actually became part of a statute, regulation, executive order, or anything else with the force of law. And that's important because employers should not rely on Matilda's Law to exclude employees from the workplace during the reopening process. I want to talk briefly about health screenings. Cuomo's reopening guidance makes health screenings mandatory for employees before they come to work each day. And there's going to be a series of questions that have to be asked, such as whether employees have had symptoms of COVID-19 or tested positive for COVID-19 in the past 14 days, or if they've had close contact with a confirmed or suspected case in that 14-day period. So our biases could creep in here again. Employers might subconsciously apply more rigorous screenings to certain employees, but we don't want to do that. We want to make sure that we're carrying out our health screenings equally and applying the guidance across the board in a fair and equal manner. I just wanted to touch a little more on the substance of this guidance for the employee health screenings as consequences of these questions that we're going to have to be asking employees. If an employee has symptoms or they are asymptomatic but have tested positive in the last 14 days, then they're going to have to complete a 14-day quarantine before they can come back to work. Employees who have had close contact with a COVID-19 case, they might be allowed to continue working with additional precautions, but there's some variation by industry. So we're gonna need to look more specifically at what industry it is to know how we should treat employees in that category. Bias is, you can back up one, Mike, thanks. Bias is an issue that's always been a part of our lives. And what we're seeing now is that creeping into some really novel situations that we're facing as lawyers in this very strange time. One of those areas is managing high-risk employees, and Mike and I would like to take a deeper dive on that topic for the rest of our talk today. As employees reopen their physical work locations, certain employees are at an increased risk for severe illness from COVID-19. And so let's talk real quick about what it means to be high risk. According to the CDC, there's really two prongs of what high risk means. There's older adults, which according to the CDC is people over 65. The other prong is that people of all ages with underlying medical conditions could also be high risk. CDC has identified several health conditions that could place in an employee in that high risk category, such as chronic lung disease, serious heart conditions, etc., or another condition that the employee's medical provider identifies as putting that individual at high risk for infection. So we've defined what it means to be high risk, and the reality is that pretty much every employer is going to have to address the situation of having high-risk employees in their reopening process, and this is presenting some specific legal issues. So some of those issues that we're going to talk through today are discrimination and harassment, reasonable accommodations, PPE, as well as this interesting conundrum of an employee who is not him or herself in a high-risk category, but lives in a household with an individual that does fit that definition. So as I discussed before, crisis times can lead people to behave in ways that they might not ordinarily behave. In a workplace setting, this can give rise to discrimination and harassment. The Equal Employment Opportunity Commission and the New York State Division of Human Rights have both noted an uptick in discrimination claims since the beginning of the COVID-19 crisis. And the chair of the EEOC issued a message, which I have up there on the slide. She said the EEOC urges employers and employees to be mindful of instances of harassment, intimidation, or discrimination in the workplace and to take action to prevent or correct this behavior. So to be quite frank, the pandemic conditions are not any excuse for discriminatory behavior in the workplace or anywhere. We're focusing on high-risk employees in this presentation, but I wanted to mention a particularly problematic form of discrimination that's very relevant right now, and that has to do with Asian Americans and others of Asian descent. It is imperative that we are all aware of this issue and take steps in whatever capacity that we're able to keep this from happening. With high-risk employees, they may be vulnerable to harassment and discrimination claims or concerns because they potentially fall into multiple protected categories such as age or disability are the big ones. So in a nutshell, unlawful discrimination, it really just refers to treating someone differently based on membership in a protected category. So this can take a number of forms. For example, like a denial of a leave that an employee is statutorily entitled to receive, or discriminatory comments, or making assumptions about certain status. Those are the types of actions that could potentially give rise to actionable discrimination. And it's important for employers to take steps to prevent discrimination in the workplace, which can include reminding supervisors and other employees that it is illegal to harass or discriminate based on any protected category, including race, national origin, age, or disability. So with that, I'm going to turn it over to my colleague, Mike Hickey, to discuss some additional legal issues relating to high-risk employees returning to work. So Mike, take it away.
Thank you, Mary. I think Mary set that up very nicely as to exactly why we're talking about these issues right now. There are biases in our society, in our workplaces, and in times like this where we have choices to make and a lot of decisions flying around with workers coming back to the office, back to work, when those decisions are being made, these biases start to creep in. Mary took us through a lot of those discrimination issues, and now a big one kind of from a more practical view is, or not practical, more technical view, is the ADA. This is one of those areas where, unlike implicit bias and discrimination, which is, incredibly important to avoid and to deal with, there's not a lot of precise guidance there beyond just, don't do it, avoid it, know your implicit bias, know bias is there, and avoid it at all costs. And when it comes to the ADA, we have very precise rules that are spelled out in regulations that we need to follow. The problem is those rules were written years ago without anyone thinking that we could ever be in this current situation. So the EEOC is the U.S. Equal Employment Opportunity Commission, which interprets the ADA, particularly when it comes to workplaces and private employers. The EEOC has come out with a lot of guidance related to how to accommodate employee issues in this situation with employees who are coming back to work. So under the ADA, the Americans with Disabilities Act, in general, employers must reasonably accommodate a qualified individual with a disability unless it causes undue hardship. That's the rule. Now we're going to talk about how does that rule apply in these various contexts that we are now facing for the first time ever. So just unpacking that real quick. Reasonable accommodation, what does that mean? A reasonable accommodation is when you make changes to the way things are done in the workplace to allow an employee with disabilities to do their job, to do the essential functions of their job. What's a qualified individual with a disability? Well, first off, a disability under the ADA, and it has a similar definition under New York state law, which has very similar protections to the ADA. An individual with a disability is someone with a physical or mental impairment that substantially limits one or more major life activities, which include things like walking, talking, working, sleeping, eating. Because of that definition, which was revised about a little over 10 years ago, it's a very, very broad concept. Disability under this law encompasses just about any medical condition you could think of, particularly one that is ongoing. So to be qualified just means you're qualified for the job and that you have a disability that and where you can still perform the essential functions of the job with or without that reasonable accommodation. The last part of this, undue hardship, we'll get into that a bit more later in this precise context of the pandemic. But generally speaking, an employer does not need to provide a reasonable accommodation if it would entail an undue hardship on that employer, which means a significant difficulty or expense. And it's a very high standard. It's not just any expense, it's an undue, pretty high level expense to the employer that would get them out of this responsibility. So then, when we're talking about reasonable accommodations, employers must engage in an interactive process to find the reasonable accommodation that works for this precise employee in their precise circumstances. This interactive process is required, and it really is exactly what it sounds like. It's a discussion between the employer and the employee to figure out, what's their medical condition, what are the boundaries, what are the essential functions of the job, and what can we modify, what can we do to allow you to still perform those functions in a sufficient manner. So going past the general principles, now we're talking about, we're in the COVID-19 era, we're in the pandemic. What does that all mean in this situation? Well, first off, when should we even be talking about this? When should we be even having these conversations? As most of you know, unless you were living under a rock for the last 3 months, we have not been working other than essential entities. For the most part, most workplaces have been shut down. And we're now into phase 2 of the reopening, as Mary mentioned, and we look to be progressing in a good direction. So what about this issue of reasonable accommodations? When should we be looking at it? What if we have an employee who has one of these underlying medical conditions that needs to be accommodated for the first time ever? It may have been something they've had all along. We may have even known about it as their employer, but it never needed accommodation because it didn't have any sort of conflict with the essential functions of the job. They could perform their job no problem. Now we have the potential for them coming into contact with this virus that is particularly harmful to someone with an underlying condition, one of these high-risk employees. So when should we be discussing, when should we be having that discussion with employees? Well, the EEOC pretty much verbatim said that second bullet point on the screen. Prior to an employee's return to the workplace, an employer can ask their employees to notify them if they will need reasonable accommodations based on a medical condition when they return to work. So the EEOC is saying you can do this, and honestly, you should be doing this as an employer. And sorry, I am so just it's ingrained in me to always be talking to employers because that's what I do. That when I say you, it generally means you as an employer. If that's not your particular circumstance, sorry. But when should employers be having these discussions? They should do it before the employees are coming back to work. Be ready to hit the ground running, get those accommodations in place. So yeah, the EEOC says you can do it, but employers should be doing this. And think about, it's not just underlying health conditions. It's not just high risk employees. It's not just conditions that have been there all along. It could be conditions that have come up merely because of COVID-19, or at least at a minimum have been exacerbated by COVID-19. Think about mental health conditions, extreme anxiety, things like that, that obviously would have been impacted by this crisis. They have an impact on daily life activities. They constitute a disability. Those mental health conditions very well could be coming into play for the first time for a particular individual and need to be discussed and potentially accommodated. So in the accommodation process, someone comes to an employer and says, yeah, I'm planning to come back to the workplace and I need an accommodation. What is the discussion? What is the interactive process? Well, first off, can you ask for medical documentation? Well, in general, the EEOC and ADA regulations and New York State regulations allow employers to ask for medical documentation to support the need for the accommodation. So it may be that they have this particular medical condition that's causing this one issue in the workplace that it needs to be accommodated so they can fully perform their job. And an employer can verify that through requesting medical documentation from the employee's doctor and have that discussion, engage in that engage in that interactive process with the employee. The EEOC continues to say, consistent with what we as labor and employment attorneys have always understood, that you can request that medical documentation now. You have an employee coming and saying, for the first time, I have this underlying health condition. I'm very concerned about being in the workplace. I need some sort of accommodation. Well, the EEOC says, yeah, go ahead and ask for the medical documentation like you always would have. However, the CDC and OSHA, both federal agencies, recommend not doing that, or at least they have been taking that position throughout this pandemic. And it's not because of any discrimination or ADA issue per se. It's actually because they don't want to overburden medical professionals at this moment. They don't want people going out to see their doctor when they don't necessarily have to. Really, this conflict between these agencies just shows that you got to strike the right balance. You have to be very flexible in this moment as an employer. Employers need to, only really request the documentation to the extent it's necessary. Don't do it as a knee-jerk reaction to a request, but instead weigh the pros and cons. If you really need something, then talk to the employee about it. See if they have something already from their doctor that doesn't involve, going to see the doctor right now, and just be flexible. As I discussed, there are going to be many situations right now where employees are coming back to work and disclosing for the first time medical conditions that never came up before. They have a heart condition, AFib, it's something you would have never known, but that's on the list of conditions that the CDC is telling us cause an employee to be high risk. So that employee may say, I need an accommodation. That accommodation may be, I don't want to come back to work, period. And that's something we would have to discuss with them. Is a leave of absence something that's possible? Or maybe it's, I can come back to work, but I don't want to be near anyone. I need to be sectioned off. I can't sit at my same desk that I used to sit at. I need to sit somewhere else. And we have that discussion and we engage in that process, and we have a duty as an employer under the law to do that. And the benefit of surveying them before they come to work is to get all this out and get all this ready before they hit the ground, get back to work, and we're, back doing what we need to be doing to get our business working again. So what may an employer ask if a high-risk employee requests accommodation for an underlying health condition? Well, this is not just the medical documentation. We talked about that, but what does this interactive process look like? What does the discussion look like? You know, it'll involve questions like how the disability creates a workplace limitation. You know, what's the condition? Why does it impact their day-to-day responsibilities, their essential functions? Ask about whether the requested accommodation could effectively address the issue. Whether another form of an accommodation would effectively address the issue. These are also questions that commonly are asked of doctors. You know, documents will be sent to doctors to kind of flesh out exactly what types of accommodations are needed. But in this situation, again, employers are going to need to be more flexible than they used to be. There's many employers that would just send out a questionnaire and say, get your doctor to fill this out. But just be mindful that doctors are burdened right now and that it's not easy to get in to see one. Then ask questions along the lines of, you know, how a proposed accommodation will enable the employee to perform the essential functions of the position, because that is the end goal. That's the point of the accommodations, is to allow the employee to do the essential functions of their job. Now, on the flip side of things, you know, that's all focused on employee, you know, is coming back to work, and that's the plan. And we may have an employee who, because of their underlying health condition, you know, really doesn't want to come back to work. And we will need to talk to them about everything that I just said. You know, can they continue to stay home? Can they be in a different part of the workplace? But let's kind of flip that around. What if an employer knows an employee is high risk, has serious concerns due to the nature of their workplace that they come back to work, and the employer wants to basically bar them from coming back to work because they are too concerned about the potential exposure there? Or maybe we have an employee that, because of, you know, what they've been doing or the kind of activities they've been engaging in, we believe that they're a risk to exposing the rest of our workplace to the virus. Well, in general, when the root cause of our concern has anything to do with a medical condition, then we can't just bar them from the workplace based on that medical condition. That would be disability discrimination right on its face. The only time that we would be able to bar them from the workplace would be if we found that they posed a direct threat to the health and safety of the rest of the workforce, and that direct threat could not be eliminated or reduced by a reasonable accommodation. So we have someone that's high risk. We're concerned as their employer. They're not particularly concerned, but we are seriously concerned that this, you know, older worker with a known medical condition is going to get infected coming back to our workplace. What do? Well, if we're going to bar them, if we're going to put them off on leave, you know, it has to be because there's a direct threat to their own health, to their health and safety. And that direct threat standard is very high. The EEOC has said that it has to pose a significant risk of substantial harm to constitute a direct threat. And that direct threat analysis has to be very, very particularized and individualized inquiry. The employer is supposed to consider things like the duration of the risk, like how long is this risk going to go on for, the nature and severity of the potential harm. In this situation, if we're concerned about them contracting a virus that could kill them, that's clearly present. The likelihood that the potential harm will occur and the imminence of the potential harm. You know, in the right scenario, I mean, if we're talking about a truly high-risk employee who's going into a workplace that's pretty densely populated with employees, then, you know, that analysis is probably going to support even that high standard of a direct threat. But you could see other circumstances where we just have an older employee, maybe a minor health condition that we're aware of, who's going into an office where everyone's pretty spread out. Now, is that really a direct threat? Probably not under that high standard. And the EEOC has clearly stated that just a ban on high-risk employees from a workplace is absolutely prohibited. You have to engage in that individualized inquiry, that, you know, individual assessment of the high-risk criteria. So then, suggested reasonable accommodations, kind of flipping back to, we have an employee coming back to work, they're a high risk employee, they're asking to be accommodated. We engage in that interactive process. What types of accommodations are we talking about? What might be possible? Well, if they've been working remotely all along, that is a pretty good indication that maybe we can continue that. But keep in mind that you're not required to do that. Just because you had someone working remotely because the government required you to have them work remotely doesn't mean that that's now a per se reasonable accommodation that you have to provide. If you're able to accommodate them in another way that allows them to more effectively do their job, if their job is one that is far more effectively done from the office than from at home, then you can still bring them back to work and accommodate them in a different way. Just because they've been teleworking or engaging in remote work doesn't make that just that automatic accommodation that you have to provide. Think about spacing them out, for instance, in the workplace when they return. Make sure they're away, 6 feet away from others. Under the reopening guidance that Mary mentioned, and I'll get a little more into, you're actually required to keep your employees 6 feet away from each other. And if you can't do that, or there's moments that they're not able to, you have to require them to wear a mask, to wear a face covering. Also think about sanitation and hygiene protocols for all employees to allow them to work in the workplace. The EEOC, those were all CDC recommendations. Oh, sorry, I see Kim. I'm guessing I know why
No,
she's
I was
saying.
just going to say, there are questions, but also there's questions about the code. Should I say it or should someone from Buffalo say it? But we have to give the CLE code. People want to know what it is.
Yeah, I think, Mary, what was it?
It's Let's Go Buffalo.
All lowercase, all one word.
No spaces, no capitalization, no apostrophe. LETSGOBUFFALO.
Thank you. Sorry to interrupt, but they need that to get their credit. We do have 3 or 4 questions when you're ready.
Yeah, I mean, this is a good time since we just did that. So I'll just read them out loud and, answer them off the cuff in front of all of you. But are employers bound by HIPAA if they collect the medical information? Who can they share the results of the survey with in the workplace? So a couple things, and actually this kind of hits on something that I had meant to mention earlier. When we're talking about talking to employees before they come back to work about potential accommodations that they may need, you can absolutely have that conversation. You can ask them if they need an accommodation for a medical condition, but you cannot, as the employer, compel them to disclose a medical condition. If they don't want to disclose it, if they don't want to ask for an accommodation, you can't compel them to do that. You can't force them into it. And kind of on the flip side of that, if an employee does not ask for an accommodation, the employer has no obligation to provide it. So back to the question, are employers bound by HIPAA? No, employers are not generally bound by HIPAA. HIPAA really only protects a patient doctor, patient medical provider relationship. So healthcare providers with their patients have to comply with HIPAA. Employers don't when it comes to their employees. However, employee medical information is protected under the ADA, the Americans with Disabilities Act, from disclosure. So it still has to be, when it gets collected, it has to be maintained in a confidential manner. They should not be sharing it with anyone who does not have a legitimate business need to know the information, like a supervisor, a direct supervisor, may need to know something about the accommodation or the medical condition, but other coworkers don't, and they shouldn't be sharing that with those people. The ADA does protect it from being disclosed and requires confidentiality. There seems to be a contradiction. This is the next question. Seems to be a contradiction as to whether employer can bar a high-risk employee if the threat to other employees, not to the employee him or herself. Please clarify. So in general, an employer could not just bar a high-risk employee. Absolutely. They would have to engage in some individualized assessment that there is either a direct threat to the employee, him or herself, or to the coworkers. So that same direct threat analysis would apply. You'd have to find that there was a serious risk of harm to either the employee, him or herself, or to their coworkers. The question about a family member that lives with someone, we're going to get to that later, actually. Does plexiglass or other material separators eliminate the need to keep desks 6 feet apart? I would encourage you, if you are working in a workplace or are an attorney for an employer or a business that is in one of the phases of the reopening, thoroughly look at the Forward New York website and the guidance for your particular industry on there. A plexiglass glass separator, I don't know if it necessarily eliminates the need to keep desks 6 feet apart. I believe it does. Actually, I'll take that back. I believe it does, in the right circumstances where it can be effective, eliminate the need for a face covering. And the face covering is really only needed when you are less than 6 feet apart. So that may be appropriate. But again, I would definitely thoroughly review New York State's reopening guidance. I can almost guarantee there's an answer to that, or close to an answer to that in there. So back on with the show. The next slide. If there aren't changes to the workplace that can be made, that question raised a good one. What if an employee is concerned because they are going to be too close to their coworkers? Maybe they're 6 feet apart, but that's still too close for them because they are high risk. Can we put up some kind of barrier? Can we protect them in some other way? These are all actual kind of physical changes in the workplace or changes that can be made in the workplace. But what if none of that's possible? Or what if none of that actually eliminates the risk and allows the employee to do the essential functions of their job? Are there other potential accommodations? Well, an unpaid leave of absence has long been recognized as a form of accommodation under the Americans with Disabilities Act. So employers, setting aside any leave law like the Family and Medical Leave Act, FMLA, or New York State's PFL, or any other leave law you can think of, the ADA itself as an accommodation does require employers to provide an unpaid leave of absence, in those situations where the employee just can't come to work and perform the essential functions, even with some accommodation. That unpaid leave of absence does not need to be indefinite. I was trying to think of the right word there. An indefinite leave of absence is not reasonable, even under the EEOC's very broad interpretation. But how long that leave of absence can be is really something that's been debated in the courts for many years now. The Seventh Circuit said 6-month cutoff is fine. The EEOC doesn't even really like a 1-year cutoff. They do say indefinite's not allowed, but a request for a 1-year leave of absence unpaid may be a reasonable accommodation in the right circumstance. On the undue hardship, an employer does not have to provide an accommodation that would cause the undue hardship. But what constitutes an undue hardship during the pandemic? So we talked about, we may not, we could potentially bar someone from the workplace who is a direct threat to our workers or to themselves because they're high risk. But what about if we have a high risk employee asking for an accommodation, but the only accommodations possible would cause an undue hardship to the employer? What constitutes an undue hardship right now during the pandemic? The EEOC has offered guidance on that. They've said things like, it may be more difficult to provide temporary assignments to employees right now because we are staffed it down. We are limiting the amount of work that we're doing in many different pieces of the economy right now. It may be more difficult to remove marginal job functions because we just don't have the capacity to pick those up. It may be more difficult to bring in temporary workers to cover for this employee or to pick up kind of these ancillary functions of their job because either the risk of bringing in temporary workers or just the expense of it. And that goes to the last one, the financial inability to accommodate an employee. Often, that's the first one that employers will look at when they're trying to make the argument that something poses an undue hardship to them. But the cost of an accommodation alone does not just because it costs money doesn't mean you can just reject it. The one thing I will say is that during a pandemic, during a downturn in the economy like that argument does become a bit more possible to kind of win the day. And an employer, if they can show that because of the downturn in the economy, because of the pandemic, that they are really suffering financially and that providing a particular accommodation is going to be too expensive and too detrimental to them, then they may be able to show an undue hardship. But even when there's an undue hardship for a particular accommodation, employers still need to explore with their employees whether there's anything else that could be provided to allow the employee to still perform their job. So with that, let's do a quick case study. ABC Corporation asked its employees to identify any limitations which would prevent them from being able to return to the office when it reopens in June 2020. Peter, an employee at ABC Corp, tells HR and says that he cannot come back to the office because he is immunocompromised due to having undergone cancer treatment, and he is worried about contracting COVID-19. What should HR do? So this is exactly the scenario that we've been talking about. Engage in the interactive process with the employee. Ask Peter if there are any accommodations which would allow him to come to work. HR can request medical documentation to back up what Peter is telling them, the medical condition, and also ask for, more importantly, documentation or input from Peter's doctor as to what accommodations may be possible that would allow Peter to come to work and safely perform his job. If there are no accommodations, even after reviewing that with his doctor, then we could, as the employer, either consider remote work, if it's possible for Peter to do his job remotely, or a leave of absence. So personal protective equipment, I got into this a little already. Early on, right at the get-go of all of this, OSHA was really a great agency to look to. They came out with very extensive guidance right off the bat, as would it be expected from the agency that is focused on keeping workers safe in America. They very quickly came out with guidance talking about the type of personal protective equipment, PPE, that may eliminate some of the risk in the workplace to being exposed to the virus. So in general, according to OSHA, PPE is equipment worn to minimize exposure to hazards that cause serious workplace injuries and illnesses. Things like bloodborne pathogens has been, regulated by OSHA for years. Dust in the air in a manufacturing environment requiring a respirator. This is the type of thing that OSHA's always regulated. I don't think OSHA probably thought that they'd ever be getting into a pandemic scenario where we're now talking about every workplace potentially looking at different forms of PPE, even the, office place where I work, my office where, we're no closer than 10 feet from one another at any given time. We're still now required to think about and provide PPE to employees. Now, OSHA early on came out with this kind of analysis of the situation. They classified different workplaces into very high risk, medium risk, and lower risk. And they said that the level and extent of PPE and workplace safety protocols that needed to be undertaken in this scenario would vary based on which of these classifications you fell into. But now we have Governor Cuomo's reopening guidance. It's amazing that it was only about a month and a half ago, but a month and a half ago, Governor Cuomo first came out with guidance or an executive order saying that all essential businesses were required to provide face coverings to their employees, and that must be worn when those employees were interacting with members of the public or their customers. That was April 12th. April 15th, now everyone in New York State needs to wear a face covering when social distancing, 6 feet separation, is not possible. Now, a couple weeks ago, we start reopening in Western New York. We got into phase 2 this week, and there is specific guidance on the Forward website for New York State saying what types of PPE and other workplace safety plans and procedures need to be put into place right now, depending on the different industry. One common theme through all of that: Face coverings must be provided to all employees at no cost to them. They must be cleaned or replaced by the employer, and the employer must have enough on hand so that replacements are available and that also face coverings are available for any guests coming into the workplace. Employers must allow their employees to use their own acceptable face coverings, so something they brought from home, but they cannot require employees to supply their own. Employers must train their employees how adequately to put them on, take them off, and discard these face coverings and other PPE that is required. And employers must advise employees and visitors to wear face coverings in common areas and really any time that employees are coming within 6 feet of one another. And like I said, OSHA for forever has had different types of respirators that are required in different workplaces. Those standards remain in place. If you're in one of those workplaces, then you still have to abide by the OSHA requirements. But now we've gone beyond that. We have office settings that now all of this is required due to the reopening guidance.
Okay, I just wanted to let you know we just passed the 1:30 mark. So
Okay.
A couple of people told us that they had to go. So I just wanted to let you know the time.
No problem. I'm going to wrap this up. And I think we got started about 12:40. So I was aiming for about 1:40 for those of you that are getting antsy at this point.
Thank you.
Real quick on this, New York DOH, they issued guidance at one point early on when the face covering did not become as widespread. This is when that initial executive order came out for essential businesses, basically just confirming what we already know in the labor and employment world, that employers must reasonably accommodate employees who cannot wear face coverings due to a disability. They added some additional elements to that, but really, anytime someone can't do something due to a disability or a medical condition, we have an obligation as an employer under the ADA to engage in the interactive process and think about reasonable accommodations. In this context, obviously, we'd be thinking about things like, plexiglass separators, restructuring the work environment so those employees don't have to ever be within 6 feet of one another, particularly this, if you have an employee who's not able to wear a face covering. Really, as a last resort, would be telling the employee that they need to take an extended leave because there's no way to do this. We should explore all options before going that route. So one more case study for you. This is just a situation to kind of quickly summarize. Employer has a requirement. We're on reopening. All employees must wear gloves. One employee says, I can't wear those gloves. I'm allergic to them, or whatever it may be. Well, that's just that scenario. Look at the way that you can accommodate that. How can you allow that employees still do the essential functions of their job without wearing gloves? Maybe it's get different gloves for that particular employee, even if it might be a little bit more expensive to buy a different type of glove. Maybe it's sanitizing the workplaces where that employee works more extensively so that there's no risk of that employee spreading something to his or her coworkers. Unless this was so expensive or so burdensome that it would constitute an undue burden, as we previously discussed, the employer has an obligation to provide that accommodation. Okay, so last, high-risk household members. We had a question on this. An employer may encounter an employee who objects to returning to work because the employee lives in a household with someone who is potentially high risk. So let's look at a case study on this. Brian has been working from home. He's been sheltering with his wife, his 2-year-old, and his 80-year-old mother for the last 2 months. Brian's 40 years old and excellent health, has no reason to be high risk or have a concern himself returning to the workplace. ABC Corp, his employer, has contacted Brian to inform him that he has been placed on the schedule to come back, and as part of the reopening plan. Brian's anxious. He doesn't want to come back to work. He's not overly concerned for his own health, but he's concerned about bringing germs and the potential for bringing the virus back to his family, including his high risk, I think it was his his mother. So what do we do? What do we do in this situation? He's asking to continue to work from home. He says it's too risky to come back to work. Well, think about because it's not his medical condition, there's actually no requirement to reasonably accommodate under the ADA. But in these scenarios, we're in an unprecedented time. It's time for employers to be flexible to the extent possible, understand these concerns, understand what comes with them. Consider the types of leaves that may be available here. The FFCRA, the expanded FMLA that's been put in place by the federal government. Generally, that's going to be really only available for an extended period of time for employees who are taking care of their children, who are home from school. But maybe there's some sort of leave. Maybe it's FMLA if his family member has a serious health condition that he needs to care for them. But if it's not that, then start thinking about other things that may be done for Brian. Again, can we limit his exposure at work? Can we give him an unpaid leave of absence? Is there something we can do to accommodate him, even though it's not legally required? But unless we want to see a quick just complete turnover in workforce, we need to be flexible. We need to be accommodating even when it's not legally required. So with that, I'll go back to any remaining questions from anyone in the audience. I'm happy to stick around for a bit longer. Kim, did you see some more come up?
I think there was one in the chat. Let me grab it. It was about the main, what if the main threat to employees is the public transportation to the office, particularly in New York City? Do accommodations extend to this circumstance outside the office?
It's a really interesting question, and honestly, not one I've heard yet. I mean, if it has to do with transportation and their medical condition, the requirement is that you reasonably accommodate so that they can perform the essential functions of their job. The transportation to and from work, not necessarily, something that we would need to accommodate. However, it kind of goes back to that flexible approach and also just general disability discrimination. If someone's not able to get to work because of this current concern due to their medical condition, then we really should still be working with them to the extent possible to figure out a way that they can get to work safely. Now, paying for a cab, paying for a car service, when you look at the broad context, likely in many scenarios is going to constitute an undue burden. That's a heightened expense that may not be needed to be provided. And there's not much of a discrimination issue there where you're not providing it to everyone. If this would be the only person that you're doing that for. But, engage in a flexible approach. And I think, that is a circumstance that the EEOC may take the position that you do need to at least provide an unpaid leave of absence until this concern goes away and they're able to get to work safely.
I think that's the last of the questions that I saw that were put in the chat. So should we thank everyone and end the program? All right.
Yes.
Well, yeah.
Thank you
both.
No, Kim, take it away.
No, I was going to say thank you both, and thank you to the UB Law Alumni Association for adopting me for the day and allowing us to speak with you all. As you can see, Mike and Mary's emails are up. If you have questions on anything that they've talked about today, please reach out to them. And if we can be of any assistance at Bond, please let us know. Have a good day.